Welcome, everybody, to the June 3rd, 2022 edition of Legal Tech Week, the show in which we talk about the top stories in legal tech and innovation and whatnot from the past week. And our panel's a little bit small today. We might have one more joining us. We'll see, depending on what happens with that person's computer equipment over the next few minutes. But we've got plenty to talk about today. And not to mention, it is the official Niki Black birthday edition of the show. So happy birthday, Niki Black.
Thank you.
And actually, and Victor, you had kind of a milestone this week too regarding your book, right? Is you good?
Yeah, it's one of those made up milestones that only matter to me. But yeah, it hit 500 libraries worldwide. So I was like, oh, okay, 500. That's a nice round number. So
yeah. And what's the book?
It's called Nixon in New York. It's a look at Richard Nixon's career in big law and how it prepared him for winning the White House in 1968.
Not a legal tech tome,
but no, not really. I mean, there was some technical stuff involving Nixon toward the end of his career in the White House, but that isn't quite covered by the book.
Yeah. Well, a lot of you listening to the show already know who we are, but we'll do the introductions anyway. I'm Bob Ambrogi, and I have the blog, Law Sites, and the podcast Law Next, and our legal tech directory called the Law Next Legal Tech Directory. And Niki, you want to kick it off today?
Sure. I am Niki Black. I'm the legal technology evangelist with My Case Law Practice Management software. I write legal tech articles for at least regular ones for ABA Journal, Above the Law, the Daily Record here in Rochester, and I sometimes also write for the My Case blog. And I'm recovering from COVID, so don't mind me if I cough a little bit occasionally. Doing my best here.
Well, I hope you're feeling you're kind of on the tail end of recovering, right? You've been better. Yeah, good.
And
good.
I think it was my first time getting it. Hopefully my last. Knock on your wood right now. Wood. So we'll see.
Yeah. Hopefully, we'll see after the summer. You're going to go to any of the summer conferences? We'll see what happens then.
Yeah.
Yeah. All right. And Victor, we already know who you are, but you can introduce yourself anyway.
Victor Lee. I am assistant managing editor for the ABA Journal. I handle business of law and technology. Happy birthday, Niki. Glad you're feeling better. Hopefully, you'll recover quickly enough. And yeah, I'm glad to be here. And short. I mean, it's a small show as far as panelists, but we got a lot to cover. So I'm looking forward to it.
Yeah. And Steve.
Hi, Steve Embry. I publish, write, clean up after, take care of, you name it, the blog Tech Law Crossroads. Prior to that, I was a practicing lawyer with a big law firm for a number of years, and I'm chair-elect and soon to be chair of the ABA Law Practice Division for the upcoming bar year.
That's exciting. And Gina O'Grady may be joining us. She was scheduled to be here, and did have something come up at the last minute, but I think she's going to join in late, hopefully. And she's also having some computer problems. So we'll see how that all works out. Joe Patrice is on vacation. Zach Warren is off in the hinterlands of Honduras or Bolivia, or is he? Bolivia, rather. And won't be joining us today. But yeah, a lot of interesting stuff happened this week, actually. And Niki, since it is your birthday, I think you get dibs on going first.
Sounds good. And I just added a second. I actually wrote two things. I only had one in the doc initially, but I added a second one since we're short on people in case we had extra time. And the second one is near and dear to my heart. It's my mentor died, and I wrote a piece about him. But the one that I wrote, put in there that's legal tech related is my ABA Journal column from May. And that was about top trial presentation tools. And the reason that I wrote that was my past two articles for the ABA Journal were about remote tools to facilitate depositions and remote tools to tools to facilitate remote trials. And as a result of those, I sometimes get emails from people who read my articles that are asking my opinion on different types of technology. And someone emailed me and wondered if I'd written about trial presentation tools. And I actually never have for the ABA journal. I have for other outlets. And I figured a lot has changed since I last wrote about it, and it was time to write a piece on it. So that's what I wrote about in May. And there are some some new ones. For a long time, TrialPad kind of had cornered the market, other than the mainstays that were premise-based, which I also talk about in the article. But there's a couple of other new additions that have been added to the mix since I last looked, and there was even one that was in beta that hasn't quite been released. But after I wrote the article, I think it was the CEO emailed me and said they were close to being released and it'd be in the App Store soon. That was iLitigate, I think. But there's a bunch of interesting tools available for people that want to have actually like trial presentation tools. So definitely take a look at the article. I sort of went through the ones that started with iPad apps and then moved into, there are some that are actually like premises-based tools, but one of them had an iPad app. I think it's called Exhibit A, had an iPad app available so that you could present from the iPad app rather than the computer, which tends to be a little bit more intuitive when you're in court trying to throw exhibits up onto the screen. So that was kind of cool that they had that sort of integration between those two different operating systems, if you will. And then I also just threw in the mainstays, which were Q and what is the other one? I should know it because it's been around forever.
Trial director.
Trial director. Yeah, I mean, those are the premises-based ones that people have been using for years, but they typically do require someone with knowledge of the software to set it up and teach you how to use it. And it's a lot more complex and quite frankly, a lot more costly. So typically only larger firms tend to use those. So, I mean, I'm not sure how much there's not a lot of debate, I don't think, about this particular article, but it's got a lot of useful information. And so I thought it was definitely worth highlighting.
This is it's actually a subject, Nikki, that's near and dear to my heart. I think, as most of you know, I'm on a faculty of a defense trial lawyers group, and we actually have hosted 2.5-day intensive training on trial presentation technology, and where people get acquainted with the technology, then give presentations. And with the thing that we typically stress is the ability to use a iPad in the courtroom and not have somebody sitting in the hot seat where you have to say, can you pull up that exhibit? No, not that one. No, the other one. Yeah, that kind of stuff is quite remarkable. And so, yeah, I enjoyed the article. I think you hit all the highlights and most of the things that we cover. We do stress the iPad and the lit software tools because we have people of various experience levels, and the easiest way we found to get people used to technology in the courtroom is the lit software TrialPad stuff because it's so intuitive. And the other thing we always tell people is that the course is entitled trial technology, trial presentation technology, but really all of those tools can be used for any presentation, whether it's to a mediator or to a client or what have you. And it really doesn't matter whether you try cases all the time or never try cases. I mean, it's just the technology and the skills in using them are pretty applicable, for just about any lawyer, because we all give presentations as lawyers, right? Whether you're a tax lawyer or a M&A lawyer or what have you, and being able to convey information that, in a way that the technology enables is pretty critical. So thanks for writing it. I enjoyed it.
So you were inspired by somebody asking you about this and not by the Johnny Depp trial. Is that right?
No, but I did manage to tie that in at the beginning because
I saw that.
Not, right?
Right.
But that trial was super interesting because it was not only was it televised, which doesn't, it only happens sometimes, but there were witnesses. There was like a witness driving in his car while he was testifying. There were witnesses that had pre-recorded testimony. There were witnesses appearing live remotely, and then there were live witnesses. So it was really interesting to see all those different elements in a single trial that, not to mention, had all like the salaciousness of like celebrities and, you know, it just had so much entertainment value on top of it. And I think actually there's a segue, right?
There is a segue because
Yeah.
right, exactly. Going for that segue because as it happens,
That's Bob's job, Nikki. You're-
Victor's pick of the yeah, that's right. Come on, what am I going to do here if you keep taking away my segues? But yeah, Victor has a piece or points to a piece this week that's very relevant to that. Victor, you want to talk about that?
Sure. But I guess before we start, just like one last thing about
Yeah,
Nikki's piece. Not to toot my own horn, I edited it, and I didn't do much on it because her pieces are always very well written and always fact checked and everything. So we don't have to do that much. But what I liked about it was it kind of took me back to when I first started practicing, and like when we would prosecute DWI cases, drunk driving cases, we would have to wheel because our office was like kind of down the street from the courthouse. So we had three of those giant of those old like TVs, like box TVs with like the vacuum tubes and that kind of stuff, and they were on like those wheelie things that you have in school. Like if you have like a school presentation or whatnot, you'd have like this big metal grate thing that you put the TV on top of so people could see it, and then we would have to wheel it all the way. Well, first we had to sign it out. Then we have to wheel it up to the courthouse. And if we didn't bring it, then we couldn't play our tapes, our DWI tapes. So the idea that now that there's a software that would have allowed us to do it like more easily without doing all that, that actually made me very happy.
But before we leave that point, just real quick, just one other observation that I have had in teaching this course is that when you get lawyers to start using trial technology, they will take the story that they want to tell and then begin melding the technology into it that they now know how to use a little bit to enhance the story that they want to present, right? Instead of a lot of times, if you've got somebody in a hot seat, you sort of like, oh, this is a nice bell and whistle, so I'll tailor my story so I can use this bell and whistle, and it works out so much better the other way, and the presentations become a lot more compelling. So anyway, I'm sorry to interrupt you, Victor. I was just thinking about that as you were talking.
Yeah, well, especially for the DWI cases that we would try. It's just like very often, like just based on the video, if the guy was falling over and like couldn't walk the straight line or whatnot, then it's like, all right, slam dunk, we're done. It really did kind of add a lot to our case if we had that element. But then obviously if the person looked good and the person didn't look, like they were falling over or whatnot, then it made our job a lot harder. So, yeah, it's one of those where it's like, technology definitely kind of exposes, it definitely shines a light on you in a different way, and like you can either kind of rise to it or kind of shrink from it. So it's interesting.
Yeah.
But I guess the story that I picked was just obviously with the Johnny Depp Amber Heard trial coming to a conclusion this week. I just thought it was interesting how, and I've been looking at this for a while, just kind of like thinking about this, just kind of like looking at how, I don't know if this was the first trial that was extensively covered by TikTok, but it was probably the biggest one. I think that's probably safe to say. And, obviously, people who are familiar with TikTok, they understand, like Nikki, obviously, they understand that like, taking those short clips and playing them and kind of, and then if you click on one, then it'll show you more and more like that. So it's very easy to kind of fall down the rabbit hole, like based on the videos that you pick and the videos that you look at and the videos that you interact with and whatnot. So very often they can end up kind of reinforcing what you already believe, or convincing you of something that people want you to believe and whatnot. And so it was interesting, sort of how the trial unfolded on TikTok, because you had these short clips of like either Johnny Depp looking good on the stand or Amber Heard looking bad on the stand, or vice versa, but usually it was
usually it was the first way, yeah, the former.
or you had I think there was one of Johnny Depp's lawyers that became sort of an internet sensation because of some of the really like kind of the things that she was doing on cross-examination or during closing and whatnot. And so it's very easy to kind of not only take a short clip of something and take it out of context and make it reinforce sort of like your own point of view, but then kind of delivering more and more of that kind of content and getting more people to kind of see things the way you do. And it's just how TikTok works, and it kind of adds the whole kind of debate about whether or not TikTok is helping to create more disinformation, or whether it's going to affect trials down the line. So I thought it was very interesting, sort of like just how that trial just unfolded on social media, and how the role of TikTok in kind of influencing where people stood on the matter. And plus, obviously, then there's always the article goes into like all the fake accounts and all the bots that started like kind of getting on it too. So there's all kinds of things going on. I think it's going to be not all trials are going to have this. I mean, not all people care about trials this much. But for like big trials, like celebrity trials, where there's a lot of interest, like I could absolutely see it kind of, swaying things, kind of making people see things a certain way, or maybe even like disregarding certain facts. So it's definitely an interesting issue, and something that could have that could play a huge role in things down the line.
What if there had been TikTok during the OJ trial?
Well, yeah, exactly. I mean, like, could you imagine that the glove moment, like going viral like that? I mean, or the if it doesn't fit, you must have quit thing. I mean, yeah, like during OJ or during the Menendez trial, or during all kinds of trials, like it could have played a huge role in kind of swaying people one way or the other. And and obviously then also other issues involving the whole Amber Heard Johnny Depp thing that is shone a light on. And yeah, it was very interesting, just sort of like how it just exploded. Like, I mean, I knew people were interested in this in the trial, but honestly, like a defamation trial, like you wouldn't think it would be that interesting all of a sudden, because really it was like 5 or 6 statements that were at issue. There were no criminal consequences. There were no, so it's really just a matter of like one rich person taking on another rich person to see who has to pay the other one.
It wasn't just rich though. Go ahead.
Moving piles of money.
Yeah.
I thought the other interesting thing about that article was, or what struck me as kind of the most interesting thing about the article, was the number of fake social media accounts that were commenting or putting stuff out there about this case. And I don't think, you can correct me if I'm wrong, Victor, that the article has any clue as to where these social media accounts were coming from, or what the origin was. And for fear of getting sued myself by some famous celebrity, I'm not going to suggest who might have been behind them, but you have to kind of wonder whether in some ways that if TikTok becomes a significant element in trials, does that then mean that the trial teams start thinking about how do we, what's our TikTok strategy and how do we influence that strategy? I'm sure they're probably already thinking about that.
Well, I read articles that said that it was a PR campaign, and that's why there were the bots, and that's why there was so much activity, and that's why it was so slanted, in terms of what was actually being posted. So, but then I also see very real people, like lawyers on my Facebook feed that I've known for a long time, on Facebook, that are posting some very slanted stuff that seem very invested in the trial as well. So they certainly were not all bots, but that PR campaign was very successful, because even all I saw was pro Johnny Depp stuff. Like I don't think I saw anything pro Amber Heard anywhere ever. And the Johnny Depp stuff was funny.
And it does raise sort of a concern, about what this does. I mean, we've all tried cases, and we know that, you can create these little snippets of testimony and play them, and, it looks like somebody is really guilty or really not guilty. But when you sit through 2 weeks of trial as a juror, listening to all the evidence, the story begins to look differently. And yet when the verdict comes down, you have this mass of people out there who just think the jury got it all wrong. I mean, they're a bunch of idiots. How could they possibly have reached this conclusion and finding? And so, I always try to caution people when they say this. You didn't sit through 2 weeks of testimony, so you really aren't in a position to say. But it does worry me a little bit that sort of this, by doing these kinds of things, it's unavoidable that the net result may be a sort of a lessening of our respect of the jury system. And anyway, when we have the case of Bobby Ambrogi. We just being sued for defamation. I'm sure we can find somebody to help you out with representation, Bobby.
Yeah. I expect this full panel of people to represent me in that case.
Boy, you're in big trouble.
But I want Joe doing the closing argument. That's all I can say. I'm sorry.
With a glass of bourbon.
Entertainment.
With a glass of bourbon, exactly. All right. Where do we go from there? There's not too many people left to go. Yeah, we could talk about your mentor. Yeah.
Well, because talking about trials and stories, that was, Ed was a litigator. And so that's why I sort of wanted to throw it in there. He wrote, Ed was my parents' friend. And I talk about in the article how growing up in a house of medical professionals, all I heard was just disgusting stories at dinner, like either really boring or really gross. Like there was no in between. And I was super unimpressed with the medical field and the storytelling potential. But then my parents' friend, Ed Mencken, had all these great stories. And he was this criminal defense lawyer in Rochester or Syracuse that was really renowned. And I loved his stories, and I decided I wanted to be a lawyer in part because what he did seemed so interesting. And he really took me under his wing. And I used to shadow him some days, a couple times in high school, and I would go to his office to get a sense of like what happens. And he helped me get an internship in the U.S. Attorney's Office when I was in high school. I second chaired a federal trial with him when I was in law school, and it was really a great experience. It was a civil rights trial on behalf of a prisoner that Ed had taken pro bono. Did a lot of pro bono work. He was just a wonderful guy. He died at 78 of cancer, and his funeral was in Syracuse, and the DA spoke. Like, he had all these, everyone called him Eddie. I mean, Ed was just wonderful, but he loved telling stories, and that's what made him such a great trial attorney. And he wrote 2 memoirs because, of course, Ed wrote 2 memoirs, not just one. And they're all about his trial, his stories from the trenches. He's talking about some of his most famous and most interesting cases, and he goes through like the entire case. And if you knew Ed, you can actually hear him telling these stories. And you can actually hear him tell these stories because in addition to these memoirs, I interviewed him for a My Case podcast about 7 or 8 years ago. And I linked to that in my article too. But he tells some of those stories. And you can either read his books for the entertainment value or to learn what it's like to be a criminal defense attorney, or also just to get some of the best advice on how to tell a story and what juries are really looking for and how to deal with difficult prosecutors and how to deal with clients and just sort of the real life things that happens. He always talks about Sal, which is one of his lawyer friends. But Sal was always like getting indicted by the feds because he got a little too close to his friends, his clients sometimes, and would get in trouble because he would get in these schemes with his clients. But he was also this really good criminal defense lawyer. But at his funeral, the district attorney for Onondaga County was there, and one of the judges who was also a good friend of his from law school. And like, they all like teared up, which was moving because you don't usually see people at that stature tear up in public like that. And they all call him Eddie because that's what everyone called him except for me, because he was Mr. Mencken and then he was Ed. But I never felt super comfortable calling him Eddie. So, but he was all about the stories and telling stories the right way. And that's a big part of what his books were, his memoirs were about. So I definitely recommend you, if you're interested at all in becoming a criminal defense lawyer or just reading sort of Rumpel stories, but with a modern twist, his memoirs are great for that. So, and I'll miss him. It's really sad.
Yeah. Well, I'm sorry. Sorry for your loss. And he sounds like an amazing guy.
He was.
We could
like Debbie Downer. Now what?
I know it. And I don't even have any bourbon here. Well, I probably when you're feeling down, nothing better to talk about than criminal justice algorithms, which fortunately Steve just happens to have a story about that. So
I was hoping you were going to use the amazing guy segue, but anyway.
not your best segue, Bob. I gotta,
what I meant is there's no cheerier person on this panel than Steve Embry who can bring us out of this slump.
So I thought this was kind of fascinating to me. I'm still trying to get my head around it, but American Civil Liberties Union came out with a commentary, and the title of it is "What if algorithms worked for accused people instead of against them?" And the notion here is we've all heard of the use of artificial intelligence and data analytics to try to predict those that pose a risk to the public. And so you can run the analytics and determine that, this kind of person is more likely to skip town, or this kind of person is more likely to commit another crime if he or she is let loose. And the net result of that, of course, is given the inherent bias in the data, you get statistics like, Black people getting sentences that are 19, almost 20 times longer than white people. So what the ACLU did in conjunction with Carnegie Mellon and Penn, University of Pennsylvania, is they sort of flipped the question, and they said, let's ask what risk the system poses to the accused, and try to determine if we can use the data to show that a particular person falls into a group that is likely to get disproportionately exaggerated sentences, or not be allowed any sort of pretrial release. And as it turns out, at least according to the study and the commentary, which they say was peer reviewed, that that's possible to do. That you can create this set of data to show that a person with this age group and this history and these sorts of things will fall into a group that has traditionally received greater sentences. And from that you could enable public defenders, or whoever is defending the accused themselves, to be able to begin arguing against sort of the lengthy sentence that might be imposed, or any other pretrial conditions that might be imposed, and actually have some data to back it up. Which, who knows how far that'll get you, but it's certainly better than nothing. And it also sort of counterbalances, it seemed to me, this notion that let's use data to determine the risk that this person poses, and sort of flips it on its head and said, well, there's another policy concern, and that's the impact of the system on the person, that not only involves the sentencing and not only involves pretrial procedures, but also the impact down the road. And so there's that aspect. That the article also cites something called the First Step Act, which I didn't know existed, but it allows federal courts to look at sentencing reductions where there's, quote, extraordinary and compelling circumstances, unquote. And the commentary was saying, well, this kind of data could be helpful. Now, Bob, you may remember at Tech Show, the keynote from the African-American woman who was imprisoned for a very long time, when the charge against her was conspiring with a drug dealer, and the drug dealer actually got no time, partly because he was killed before he got to trial, but she ended up with a sentence that was almost as long as and maybe longer than he would have received, and fortunately her sentence was commuted. But it's a prime example, and that was another thing that the commentary pointed out, that this kind of information and data could be very helpful in trying to get some clemency decisions from the executive branch that might not be available, or might not be as easily to justify without this kind of data. So I thought it was interesting on a couple of runs. One, because of the impact on the criminal justice system, but also because I thought it was interesting that they actually ask a different question of the data than the standard question, and got a really meaningful kind of result, which goes to show you that it's a lot of what you do with data depends on the question you want to ask from the data. So I thought to me it was pretty interesting, even though I have no criminal law experience, and certainly appreciate, Niki, your thoughts on it, because I know you have. But it seemed to be a useful exercise, and maybe a useful tool that could be developed.
I mean, I tend to be cynical about it. It may be a useful tool and a theory of how it could be used, but I'm a little bit cynical about the fact that it would actually be used in that way, because the criminal justice system generally does not operate in favor of the defendants, and so it's, I love that the ACLU is doing this, because at least they're trying to show that you can use this data in a way that is beneficial, and if nothing else, it arms the criminal defense attorneys with data to start creating records that could hopefully assist on appeal, or just start creating more trends to show that, we're making these arguments, it's not making a difference, and maybe it can eventually rise to like some sort of constitutional level claim. I mean, I clearly have not thought this through, but I just tend to be so cynical about the criminal justice system, though, because it's pretty rare that when if things can go be used for or against, or inferences can be made for or against the defendant, they tend to almost always things seem to go against the defendant's interests in any given case. So, but I think it's important to go through these exercises and to have these studies and at least posit ways that you can use these tools in ways that would be beneficial to actually seeking justice. But sometimes I feel like the criminal justice system does not always do that as a whole.
Or maybe it doesn't ever do that. Maybe it's better. starting to wonder about that myself. Yeah, and I think that's right. But again, it's like you say, it's at least a start. It's something, and who knows? The more questions we ask, the more things we push our data to do, maybe the more information and the more light that can be shed on, bad practices, unfair practices, practices that are not consistent with justice, that weren't there before. So I thought it was kind of kudos to those guys for coming up with this approach to try to do something from an analytical data standpoint that has often been just anecdotal as opposed to anything else.
Well, yeah, and I think that one of the other things the ACLU did, it was a number of years ago, but where they this particular study I'm thinking of, I felt it was more impactful because it showed the weaknesses in the AI versus trying to show ways you can use it differently, which was the facial recognition AI Amazon's, I think it was 2017, but where they ran Congress through it, and it identified the vast majority of people of color that were members of Congress as potential criminals because it said they matched, had mug shots in the systems. So, I mean, that one was just so striking, clearly this is broken if it's, and it's only misidentifying the people of color members of Congress, So that one that type of attack seems to me to be the most effective way, like almost an attack rather than this, well, you could use it another way. Because I feel like most people that are prosecution oriented are like, yeah, well, we could, but we're not going to. We're perfectly happy the way we are, versus damning evidence that shows that something that they're relying on, it's easier to pick that apart in court, and I think, and be like, this facial recognition technology is faulty and broken, it doesn't work and inherently biased. And I think sometimes that's an easier argument to make to get a piece of evidence knocked out rather than changing an entire policy almost. I'm not sure if I'm not stating it quite as clearly as I could, I don't think, but I think it's important work that the ACLU does to kind of challenge technology in general and suggest these alternate ways of using it.
Yeah, and I could think of situations where, public defenders, and my son-in-law is a public defender. So, I said I'm kind of sympathetic to the situations that they often find themselves in. But, now when there's a plea bargain to be put on the table, if you had data like this, you can say, well, no, why would I agree with that? Because that's 5 times a harsher sentence than other people get. And so it at least gives you some leverage, I guess, that maybe you would not have had before. Whether it does you any good or not, I don't know, but because I've never been in that situation. Well, actually, I did have a criminal appointment when I was right out of law school that was completely baffling to me, and was glad when somebody stepped in to help me. But yeah.
One thing that Ed talks about in his book, in one of the stories that he tells, is he had a client who, the case against the client that was actually being tried was not super egregious, wasn't a particularly strong case, but the prosecutor had decided he was a bad guy. And I remember prosecutors telling me this, well, he's a bad guy. I don't care if I don't care if the case sucks. It's a bad guy. We want to get him off the street. Like when they have that mentality about defendants. They look at the
Yeah.
record, they make a decision about them, whether they're a bad guy or not, or whether they maybe have some rehabilitative potential, really rehabilitative. But and once they decide they're a bad guy, forget about it. Like, they don't care if they have a crappy case. They know that statistically, if they try a case, there's a better chance than not that they're going to get a conviction, because the cards always fall in their favor. And so that's where it, you know, that's the problem with being a public defender and saying, well, statistically, I mean, you absolutely can make the argument. I think you should when you're trying to plea bargain, but when you're like, statistically, that's a really, you know, you're being racist. You know, white guy wouldn't get this. Like, I don't want to talk about statistics or, you know, generalities. I'm talking about this guy, and this guy's a bad guy, you know, and they just go down this whole path. And so that's sometimes where the difficulty comes in. They don't care about reason. They care about getting the bad guy off the street.
Getting the conviction. Yeah.
Right.
And
Victor,
then
were you trying to say
there's
something?
Yeah. Oh, go ahead.
It's not, Victor, were you trying to say something? I saw you trying to say something there.
Oh, well, no, I mean, it's just, well, you know, as a former prosecutor, but no, it's
Except for you, of course.
no,
Let's add that.
no, we did it all the time. It's just kind of like, if someone had a rap sheet that looked more like a book than a sheet, then it gets to the point where you're just kind of like, well, you know, just, we can't, you know, we wouldn't be allowed to even offer a deal, because it's kind of like, well, either this guy goes away for the max, or we didn't do our job. And you know, I mean, I can see both sides of that argument, because on the one hand, maybe this guy really is a bad guy, and he, you know, is going to keep, he is going to keep, or he or she is going to keep, you know, getting arrested, doing, you know, breaking the law, you know, hurting people or whatnot. But then also it's kind of like, well, okay, but then why? Like, why is this person always in the position where, you know, they feel like that this is what they have to do in order to either, you know, make ends meet or support themselves or whatnot. And it's just, I think just, you know, anytime you have, you know, data that comes out that challenges sort of like the, just the conventional wisdom of what a lot of people believe. Because like, what's the conventional wisdom about these, you know, mandatory minimums and you know, like these long sentences and whatnot, right? It's kind of like, well, you know, the argument is, well, they impact, you know, they impact certain people more harshly, or, you know, just is not applied uniformly and whatnot. And so then people who are in favor of them, or people who don't want to, you know, see any kind of meaningful reform, they just say, well, the reason why these people are the ones that are getting the sentences because they're doing the crimes. And it's and it becomes a very simple kind of answer for them. Like, well, they shouldn't have broken the law. They shouldn't have done A, B, and C. Otherwise, they wouldn't be serving this much time in jail. And, you know, anytime you can kind of, same thing with the predictive policing. It's like, oh, well, we send the police where there's the most crime. And then so where do they end up? Usually end up sending the police to neighborhoods overrun by minorities. And so anytime you have, you know, studies that can kind of challenge those kind of assertions, it's a good thing, because that way it forces people to kind of get out of that method of thinking a little bit, even if they end up just saying, like, oh, well, forget it, I'm not gonna listen to that study. I'm not gonna regard it because I'm not racist, I'm not sexist, I'm not this. But, you know, ultimately, you know, like the more data that comes out that shows this kind of stuff, it's, you know, it can only help. It can only, you know, especially the people in power, that'll kind of force them to kind of look at things a certain way, because that mentality with the prosecutor's office is still very strong. This idea of, well, you know, I can't let this person get out on my watch, and as long as I do what I think I have to do, then I can at least face the voters in 4 years and be like, well, hey, you know, we put so and so away. We tried to put this person away, and, you know, we did our best, and that's that, you know.
Yeah, I'm like Steve. I've hardly done any criminal work in my life, but I've done a little bit, only because I used to have to when I was practiced in the Virgin Islands, where every lawyer had to take criminal appointments, whether you were a criminal lawyer or not, which wasn't always the best thing for the defendant, but that was the case. But I mean, it seems to me that at sort of the baseline, the job of a criminal defense lawyer is to introduce doubt into the government's case. And it sounds like by kind of flipping the algorithms in this way, that the way the ACLU article talks about, that can be a powerful tool for introducing some doubt around some issues in a case. It doesn't necessarily have to be something that turns out to be decisive in the case, or that, you know, actually sways anybody's ultimate decision in a case. But if you can at least get the judge or maybe the jury thinking a little bit about, well, maybe maybe there is a bias in the other direction here, or something like that. That can end up being to the great advantage of a criminal defendant in a case. So I think it's a really interesting article. All right. Well, I will turn next to myself and talk about something I wrote about this week. There was actually a lot of interesting stuff this week. Oh, actually, one other point I wanted to mention, just because Niki alluded to facial recognition. If you didn't read Kashmir Hill's story in the New York Times Magazine this past Sunday on this new face search engine called Pim Eyes, read it, because it's really scary. I mean, it's alarmingly accurate, and it's available to anybody to go out and find. Basically, her premise is that this finds photos that nobody else is finding out there, and that it's incredibly accurate. Even if you post a photo of somebody wearing a COVID mask or something, it can still pick out their facial features and find related photos, and really scary technology. Anyway, that's not what I wrote about. What I wrote about was BriefCatch, which I've written about before. BriefCatch is one of these legal editing programs out there. It's a Microsoft Word add-in, and in the past, I've written reviews a couple of times in which I've taken some Supreme Court opinions and run them through some of these various editing programs. I've done it with WordRake, and I've done it with Perfectit, which is more of a proofreading tool than a style tool. And I'd done it before with BriefCatch. BriefCatch had just come out with its all new and improved version 3 just a few weeks ago. And I'd been kind of looking for a case to do it with, give it, kind of run it through BriefCatch and see what I'd find. So with so much attention being paid, justifiably, of course, to this leaked opinion from the Supreme Court overturning Roe v. Wade, I decided to try it. I was a little uncertain whether I should, only because it's obviously such a hyper controversial opinion, and it's such an emotional one for so many people. But my reasoning was ultimately that it would be just interesting to see how software like this works in a case like that, and also that ultimately a lot of the cases that lawyers are going to want editing help with are cases that are involving very controversial or very difficult issues, and you could argue that's when they most need the help of a good editor, whether it's software or a colleague down the hall. So I ran the case. I downloaded the PDF from Politico, which is the one that had gotten the leaked opinion, and cleaned it up a little because it had been a scan, and Adobe didn't convert it to Word all that easily, but ran it through, and so it was kind of interesting to see what happened. I mean, I think the kind of the most what struck me the most is kind of the fact that this is just software, and here you have this opinion that is such a hot button opinion for so many people that just about anybody who reads this opinion, no matter where you stand on this issue, you're going to have a strong emotional issue. But BriefCatch is just software, and it has no emotional reaction to the opinion. It just looks at it with this sort of cold objectivity that's a little bit almost off-putting as you look at it. But BriefCatch does a couple of things. One is it gives a document an overall score for things like how well it engages with readers, and how its concision and readability, and its flow and cohesiveness, and that sort of thing. A little bit to my surprise, given the not just the subject matter, but the fact that there's a whole lot of citations to archaic law from centuries ago and everything else, the BriefCatch scored it fairly well. It got way above average scores in just about every category for its overall writing. But then when you go through the editing suggestions, I mean, they tend to be there are a lot of good suggestions, but they tend to be kind of very mundane stuff that you know it would help anybody writing a brief, but it doesn't shed any kind of insight or light on the opinion in any substantive way. It really is a pure uh, 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 software that just purely offers these suggestions. But I mean, there were a couple of places where it was almost kind of striking, I thought, in its uh, some of the comments it made. There was probably the most striking one was there was a point in the opinion in which Alito is talking about the analysis of determining whether a regulation, quote, presents a substantial obstacle to women. It goes on to say, then a court needs to know which set of women it should have in mind and how many of the women are in this set find the obstacle substantial. But this phrase, BriefCatch picked up on this phrase, presents a substantial obstacle to women. And I thought it was really interesting because it presented this whole list of alternative ways of phrasing that, which were phrases like hinders women, inhibits women, impedes women, impairs women, thwarts women, foils women, which of course it kind of goes to the very heart of the criticism of this opinion, and certainly not anything that Alito, were he using BriefCatch, would probably want to adopt any of those phrases, because if anything, they are counterproductive, I think, to the certainly the position he's trying to put forth in this case. So I mean, the bottom line was, there's nothing. It does a good job. It's a useful tool, but putting it against a controversial opinion doesn't really do anything anything different than it would do putting against any piece of legal writing. But it was kind of fun to do anyway.
Yeah, I thought it was interesting because kind of like, well, I mean, obviously with the, like just reading, I mean, the first time most people write the opinion and whatnot, it's obviously comes across as a very strong, very strident, very sweeping opinion, just with the way it overrules Roe and says it was wrongly decided from the beginning and blah, blah, blah. But then you kind of look at all the ways, all the times, at least BriefCatch, caught like passive voice, use of passive voice, or, use of like, where maybe like the language could have been written stronger, or, I think there was one that was kind of like, what was it? Has come to light or something like that, and like you're like, oh well, you could have used a more vivid phrase there. So I guess it was interesting to kind of see like sort of like so there are hedges in some places, but probably not in like any area that would like make it a substantive thing. But it was just kind of just a sort of like a writing exercise, kind of like, well, we all assume that it was we all consider it to be a strongly written opinion just because of the content of it, but then you kind of look at all those instances, kind of like, oh well, he hedges here and hedges there. So I thought it was interesting from that aspect.
Yeah,
I always found it interesting when I was using some of these tools and writing briefs, and I would quote language from an opinion, and inevitably whatever tool I was using would find that quote and just butcher it. And this is horrible. Don't use this. Don't say that. Wrong language, passive voice, use better language, ambiguous, too many words. It just would go, well, yeah, that's pretty much our judiciary. Yeah.
Yeah. Yeah. I mean, it's also interesting because there are a couple points where, again, BriefCatch would make a suggestion, like Victor said, maybe it is pointing out passive voice or something, and you just wonder what the thought process was, because you have to believe that they're thinking very carefully about the wording here, right? I mean, they know this is going to be, one of the most controversial opinions ever, that they're walking on eggshells here in terms of overturning established precedent. And they're discussing an issue that's one of the most controversial and hot button issues in the country. So he's got to be thinking about the wording very carefully. And there are these places where, like he'll use the passive voice, which is one of the features of the passive voice is you're kind of not attributing an action to an actor, and that's got to be intentional in some ways, so it is interesting. According to Ross Guberman, the founder, he says several Supreme Court justices actually use the product. So we have no idea whether Alito might well have already run his draft through BriefCatch even before I got to it. But
Well, the passive voice issue is particularly interesting because that's a tool to be used, and whether they'd use it intentionally or not, it like removes response. It puts a buffer between someone and the responsibility for actions.
Exactly.
You know, I hit the dog, or the dog was hit by me. You know, it's like the dog just happened to get hit, and I was there. You know, like, and it's this way of sort of removing yourself from responsibility or distancing yourself from the consequences of your actions. And so it was either intentional, or it could have even been like a subconscious thing where they're distancing themselves from the actual consequences, or you know, what the effects this is going to have on women. Instead, it becomes this, it's a way of like also making the object further removed from you, putting distance between you and the object too, you know? So there's a lot of things that may have actually been intentionally or possibly subconsciously being done, because people do that. When they're trying to talk about something complicated, but they don't want to take responsibility for what they're saying, they'll use passive voice too. And it can also just be a way to break sentences up too. Sometimes it's because when I run my writing through Grammarly, it hates the passive voice, but sometimes if you don't use the passive voice, every sentence starts off with, this is that, this is the other. So when you flip the sentence around, it just makes everything run more smoothly. It's like an advanced level of writing, in my opinion, sometimes. So
I would agree with you. And I use Grammarly too. And that you know, a lot of times it hits me for the passive voice, and I just kind of, I don't know. I can't figure out a better way to say it, and I don't have time to mess with it. So it's just going to be passive. Sorry.
I stopped using Grammarly because I felt like it was, I mean, I think, you know, once you start writing, if you write frequently, you do develop a voice, and some of these tools aren't friendly to those voices you develop, and they tend to make a lot of the same suggestions over and over again that are very rote, mechanical suggestions. And once you get to a certain proficiency in terms of writing, you know all this stuff, and you're kind of making the decision as you write, not to do something a certain way or to do something a certain way. And I found Grammarly I was just ignoring almost everything it suggested, and I gave up on it.
I've been using the Hemingway editor, which is really good for me because I tend to write really long sentences, and that's, as the name would suggest, Hemingway editor. It's like, no, sentence is too long, it's in red, but it's been really helpful to me because I do have a tendency to run on with sentences that need to be broken up into shorter thoughts.
Yeah, the period is your friend.
I agree, they can definitely remove the voice, but I like the backup. Like I leave out like to and like all these little words that you don't see when you skim through something. And that's what I really appreciate about it more than anything. And sometimes things do sound better in an active voice than a passive voice. And sometimes I think when you write a lot, you fall into certain writing patterns too. Turns of phrases that you always use, or ways to connect one sentence to the other. And sometimes it helps to have like a second eye to break it up a teeny bit. So I have to use Grammarly because I could never remember if the quote goes after the period or the quote goes before the periods. So, but for Grammarly, I'd get it wrong every time.
Of course, a lot of that stuff, there isn't even a right answer. I mean, every other different various style books disagree on a lot of these things. But
then that reminds me that there's a thing in Hemingway where it will say, do you want to use one space after the period or two?
One.
I was like, why are you giving me this option?
Yeah. Hey, before we wrap up, I'm going to put in a plug for one other story I did this week. I won't talk about it, but just I thought it was really interesting. I had this occasion to sit down with three people who are long-time sort of trailblazers in the profession of docketing within a law firm, which honestly is something I hardly knew anything about. And I had this like long conversation with them. I was going to write a story about it, and then after we I happened to record the conversation, and looking back at the recording, I thought, you know what, I'm just going to make a transcript of this because it was such an interesting conversation. So, but I didn't record it for a podcast, which I should have done. But so I just put the link in that. But you know, they call themselves the mystery department in a law firm. But it's an interesting job within a law firm that's, you know, responsible for basically tracking all the litigation and intellectual property filings and calendars and all of that. A very tech-focused job, you know, very technical job, obviously. Most usually in charge of all the e-filing and everything like that for a law firm, and yet something it just doesn't get talked about a lot. And so, if you're at all curious about what docketing professionals do, check it out. Dan O'Day says that's a great article because he knows what docketing professionals do, because he deals with them all the time, I'm sure. But anyway, and see, we didn't think we'd have enough to talk about for an hour, and here we are running out of time.
We didn't even have Joe with us, so
We didn't even have Joe or Bourbon. So, oh, I shouldn't speak for you, Steve. You know, bourbon is like grows on trees or something.
That's right. That's the only thing we drink then.
I think those bottles
we don't
hanging
even,
from the
we don't
bourbon
even
trees.
drink water. It's just always
The official state, official state drink.
Yeah.
Yeah. All right. Well, that does it for this week, I think. Again, happy birthday, Nikki, and
Happy
enjoy
birthday,
it.
Nikki.
Yeah.
Happy birthday.
Oh, thanks
See
so
you all
much.
back here next week.
Bye all.
So long. Have a good
Have a good
weekend,
one.
everyone.
Bye, everyone.